Regulation 1223/2009 is the law governing cosmetic products on the European Union market. 4 things have to be in place: a responsible person, a safety assessment, a product information file, and a notification to the Commission. Article 1 states the purpose: rules for any cosmetic product made available on the market, to make the internal market function and to protect human health. Article 2 defines what counts: a substance or mixture intended for the external parts of the body, the teeth, or the mucous membranes of the mouth, with a view exclusively or mainly to cleaning, perfuming, changing appearance, protecting, keeping in good condition, or correcting body odors. Exclusively or mainly does real work there. But it isn't the only condition. The definition sets 3. A substance or mixture intended for one of those parts of the body, exclusively or mainly for one of those purposes. A borderline product has to clear all 3. Anything intended to be ingested, inhaled, injected, or implanted is excluded by Article 2, Paragraph 2. 4 articles do the pre-market work. Article 4. Only products with a designated responsible person may be placed on the market at all. Article 10. Prior to placing, that person ensures the product has undergone a safety assessment on the basis of the relevant information, and that a safety report is set up in accordance with Annex 1. Article 11. When the product is placed on the market, they keep a product information file for 10 years after the last batch was placed. Article 13, Paragraph 1. Prior to placing, they submit the product information to the Commission electronically. The timings differ. Article 10 and Article 13, Paragraph 1 say prior to placing. Article 11 says when placed. Article 4 makes it a condition of placing at all. Article 13 carries both. Paragraph 2 requires the original labeling and a photograph of the packaging where it's legible when the product is placed. Article 4 also decides who that person is. It turns on where the product was made and who places it. Made inside, the regulation's own word, is community, and not afterwards exported and imported back. Then it turns on where the manufacturer sits, established inside, and the manufacturer is the responsible person. They can pass it on, but only by written mandate, accepted in writing, established outside, and they must designate someone inside. Imported from outside, each importer is the responsible person for what they place on the market and may designate someone else by written mandate, including one made here, exported, and brought back. That's what the qualifier on the first branch excludes. A distributor becomes the responsible person where they place a product on the market under their own name or trademark, or modify one in a way that could affect compliance. Note, place on the market, not sell. Article 2 covers supply in the course of commercial activity, paid for or free. Article 5 then lists what that person carries. Articles 3, 8, 10 through 18. Article 19, paragraphs 1, 2, and 5, and Articles 20, 21, 23, and 24. Article 14 sets the substance rules, working through the annexes. Annex 2 is prohibited substances. Annex 3 is restricted, permitted only within the conditions stated there. Annex 4 is colorants. Annex 5, preservatives. Annex 6, UV filters, and those annexes move. Article 31 lets the Commission amend them as SCCS opinions come in. So checking them is a recurring job, not a one-off. Those 3 are positive lists. A substance may be used as a colorant, preservative, or UV filter only where it's listed for that use within the annex conditions, with one carve-out in the article itself. Hair coloring products, handled separately by Article 14, Paragraph 2. Article 15 covers CMR substances, carcinogenic, mutagenic, or toxic for reproduction. Category 2 is prohibited unless the SCCS has found it safe and the Commission has adopted the measures to permit it. An opinion alone doesn't change what's allowed. Categories 1A and 1B are prohibited, with a narrow conditional exception. Article 16 covers nanomaterials. Generally, they need a further notification 6 months before placing, on top of the Article 13(1), with exceptions including nanomaterials already regulated as colorants, preservatives, or UV filters under Article 14. Article 17 permits the non-intended presence of a small quantity of a prohibited substance from impurities, manufacturing, storage, or packaging migration, where it's technically unavoidable under good manufacturing practice and the product still complies with Article 3. Article 19 is the label. 7 categories of information on the container and the packaging, with specified exceptions. The responsible person's name and address, nominal content, minimum durability, precautions in use, batch number, function, ingredients. Every one of those carries its own conditions, which is a video of its own. Article 20 governs claims. Nothing in labeling, marketing, or advertising may imply the product has characteristics or functions it does not have. Article 22 puts enforcement on member states. Checks on products already on the market through the product information file and physical and laboratory checks where appropriate. Article 25 sets out non-compliance. 12 listed grounds from good manufacturing practice through the safety assessment, the file, and the labeling requirements. The competent authority requires corrective action, withdrawal, or recall. Article 37 leaves the penalties themselves to each member state, with one requirement: effective, proportionate, and dissuasive. Not across the whole UK. Great Britain applies its own version of this regulation, broadly the same structure, but a UK-established responsible person and a separate notification. Northern Ireland continues to apply this regulation under the Windsor framework. If you're bringing a product to the EU market, the articles set the order. Establish the responsible person. Article 4. Compile the safety evidence the product needs and have the assessment and report completed. Article 10. Assemble the file around it. Article 11. Notify before placing it on the market. Article 13. Those 4 are the backbone. The regulation's other requirements run alongside them, not inside them. Safety, manufacturing practice, ingredients, labeling, claims, and post-market obligations. If you need help placing a product on the EU market, the link in the description is where to start. This is the Cosmetic file. This channel is supported by MySwissLab, educational only. Check with a qualified safety assessor for your own product.